Mr. Chairman, members of the committee, my name is James Quintero. I represent the Texas Public Policy Foundation, here to testify in strong support of the committee substitute for HB 111. You know, there's a really unfortunate schism that exists in today's transparency law, which is that the ideal, as articulated in the preamble of Chapter 552 of the Government Code, sets forth a very aspirational framework. But when you look at the law in practice, it does not measure up. One way that the law falls short is that it permits publicly subsidized organizations, associations, and quasi-governmental entities to operate in the dark. These groups consume our tax dollars without the public knowing why, how, or for what purpose. Now, at the risk of offending my friends in the room, I want to point out a few examples, two of which are the Texas Association of School Boards and the Texas Association of Counties. The former group, TASB, is one of the largest taxpayer-funded lobby groups in the Capitol. According to their latest 990 form, the group pulls in about $100 million annually, and yet we, the people, have no real sense of how TASB does what it does, how exactly it derives its revenue, or what return on investment the public is receiving. For its part, TAC receives about $48 million. Presumably most of that, if not all of it, is from public sources. The same critique applies to them as well. These concerns are actually heightened given Elon Musk's Doge investigation, which recently uncovered a host of questionable and controversial payments going from federal agencies to NGOs. Musk actually called the arrangement the biggest scam ever. Given that set of circumstances, I have to wonder if there's a similar dynamic here in Texas between Texas governments and those entities that heavily depend upon them. Now, one other way that I didn't really anticipate speaking to, but I want to give a little attention to the attorney-client privilege. The Texas Public Policy Foundation is actually involved in a litigation effort currently against Highland Park ISD, wherein the district CC'd an attorney on an embarrassing report, and they claim the attorney-client privilege exception so as to withhold that documentation from the public. My understanding after talking with our legal team is that's a relatively common tactic being employed by political subdivisions right now so as to prevent the disclosure of data and documents. I think it would be a mistake to either remove or degrade the provisions in Section 3, and so I hope the chairman will consider keeping those as strong as possible. Thank you.
Thank you very much, members. Any questions of the witness? Representative Cook.
The recommendation that you have on page 2, has that been incorporated yet, or is that?
On page 2, sir?
Yeah, it says recommendation in big blue.
Oh,
You need.
gotcha. I'm sorry.
It says amend the definition of governmental body located in section 552.0031A(XV) of the Government Code to clarify that nonprofit state associations and organizations that primarily represent governmental entities are subject to the TPIA's disclosure requirements. I don't have the copy in front of me right now. Has that been inserted into the committee sub, to your knowledge?
I believe so. Yes, I believe the language in the committee substitute is generally reflective of that recommendation. I think it's wholly necessary.
Perfect. Thank you.
Members, any other questions? Thank you for testifying.
Thank you.